Welcome back, everyone, to The Deep Dive, the show where we like to get you up to speed on some pretty complex topics.
That's right.
Quickly, but thoroughly.
Yeah.
And today we're diving into something huge.
Yes, we are.
The Constitution of India?
It's a big one.
It is a big one.
Yeah.
And, you've sent us these excerpts.
Absolutely.
And that's what we're going to dive into.
Right, anyway.
So forget all that dry legal jargon, This is like the fundamental blueprint of a nation, right?
Oh, absolutely.
It outlines who belongs, what their rights are, and how it's all governed.
That's it.
So think of this as your shortcut to understanding India's constitution. The core principles, the surprising foundational choices, the aha moments within it.
The aha moments.
Yes.
I love those.
Yeah.
Those are the best.
So you're likely looking to grasp the essential structure of Indian governance, the definition of citizenship without having to wade through all that dense legal text.
Absolutely. And it can be dense, can't it?
It can be.
Yeah.
So our goal is to really extract those key insights from these excerpts and provide the crucial context that makes it all click.
Yes. Make it all make sense.
Exactly.
Yeah.
So to guide us through this foundational document, we have our expert here.
Hello.
Hello. And together we'll explore the very definition of India, crucial aspects of citizenship, the bedrock of fundamental rights, the guiding principles for the government, the architecture of power at the national and state levels, and the role of the courts.
Wow.
That's a lot.
It's a lot to cover.
It is.
But we'll take it step by step.
We'll break it down.
Yeah.
So, okay, so let's unpack this, by looking at the very foundation, the Union and its territory.
Okay.
So what's immediately striking is how the Constitution establishes the nation's identity right at the outset.
Yeah.
Article 1.1 states, India, that is Bharat, shall be a union of states. That dual naming isn't accidental. It speaks to the country's ancient heritage alongside its modern form.
Right, from the beginning, setting the stage.
Yeah.
Yeah.
Exactly. India, that is Bharat. It's like the Constitution's grounding itself in history from the very first sentence. And then Article 1.3 gets down to brass tacks, defining what exactly constitutes the territory of India.
Yeah, the nuts and bolts.
Yes.
It's a really comprehensive definition. It encompasses not just the territories of the states and the Union territories listed in the first schedule, but also any other territories India might acquire in the future. It's forward-looking.
Oh, wow. So it's not just like a static thing. It's like
adaptable.
Adaptable.
Yeah.
And the Constitution also lays out how the map of India can change. Articles 2 and 3 detail how new states can be formed or admitted.
Right.
And how existing states can be reorganized.
Yes.
That suggests a dynamic approach to the nation's structure.
Precisely, Parliament has the authority to create new states or alter the boundaries or names of existing ones.
Wow.
However, Article 3 includes a vital safeguard.
Okay.
Any bill proposing changes to a state's name or territory has to be sent to the legislature of that state for their input.
Oh, okay. So they have a say.
It's a mechanism to ensure the states have a voice in decisions that directly affect them.
So it's not just a decision made,
In Delhi.
in Delhi.
Yeah, exactly.
The states themselves get a say.
Absolutely.
And I noticed there are clarifications about what state means in this context.
Explanation 1 clarifies that for the purposes of forming new states or altering boundaries, state does include union territories. However, when it comes to that requirement of referring the bill to the state legislature for their views. Explanation 2 specifies that state does not include a union territory. This distinction is important. Explanation 2 further clarifies that the power to form a new state includes the power to create a new state or a union territory by combining parts of existing states or union territories. It's a detailed framework for how the Indian Union is organized and can evolve.
So it's like a very carefully thought out.
Very carefully thought out.
Yeah. Okay, so we understand the physical boundaries. Now let's look at who are the people within those boundaries. Citizenship as outlined in Part 2.
Okay.
Article 5 sets out the initial rules for who was a citizen when the Constitution came into effect.
So Article 5 establishes citizenship at the commencement of the Constitution. based on having a domicile within India and either being born in India or having at least one parent born in India.
Okay, so that makes sense.
These are the fundamental criteria for defining the initial citizenry.
Establishing a clear baseline.
Exactly, clear baseline.
Right from the start.
Yeah.
But what if someone chooses to become a citizen of another country? That's where Article 9 comes in, right?
It does. Article 9 makes it clear that if a person voluntarily acquires citizenship of another country, they will not be considered a citizen of India. Under Article 5 or under Article 6 or 8, which deal with specific situations of migration around the time of partition, this underscores the principle of single citizenship that India follows.
So you can't hold, Indian citizenship and another country's citizenship by choice.
One or the other.
It's one or the other.
Yeah.
And what about the continuation of citizenship for those who qualify initially? That's Article 10, if I remember correctly.
You're right. Article 10 ensures that anyone who is a citizen or is deemed to be a citizen under the earlier articles continues to hold that status. But this is subject to any laws that Parliament might enact. Regarding citizenship in the future, it provides the level of stability while also allowing for legislative updates.
So it's kind of like it lays the groundwork, but it also says...
It can't be changed.
But it can be changed.
Yeah, exactly.
And it seems Parliament has the last word on this because Article 11 grants Parliament the power to make laws to regulate all aspects of acquiring and losing citizenship.
That's right.
So the Constitution lays the initial framework, but the details and future rules are up to...
the elected representatives.
The elected representatives.
Yeah.
Now let's move into what many consider the heart of the Constitution, Part 3.
Yeah.
Fundamental rights.
This is the good stuff.
This is where the document gets really personal, guaranteeing certain freedoms and protections to everyone.
Yeah, everybody.
But before we delve into the specific rights, Article 12 defines what the state means for the purposes of this part.
Yes, this definition in Article 12 is absolutely key to understanding who is responsible for upholding these fundamental rights.
Okay.
So the state is defined very broadly. It includes the government and Parliament of India, the state governments and legislatures, and all local or other authorities within Indian territory or under the control of the Indian government.
So it's not just like
the big players.
The big players at the federal level.
Not at all.
But also state and even municipal bodies.
Yes, even down to the local level.
That's a really wide scope of responsibility.
A huge scope.
It means these rights aren't just protected, from the central government, but from...
various levels of authority.
Yeah. And then Article 13 kind of sets the ground rules for how these rights operate, doesn't it?
Exactly. Article 13(1) states that any laws that were enforced before the Constitution came into effect and which contradict Part 3 are void. To the extent of that contradiction, even more powerfully, Article 13(2) prohibits the state from making any future laws that take away or limit the fundamental rights, and any law that does so is also void to the extent of the violation.
So they can't make a law that takes away a fundamental right.
Yeah.
That's very clear.
This establishes the supremacy of fundamental rights. Article 13(3) further clarifies that law includes not just formal legislation, but also ordinances, orders, rules, regulations, notifications, customs, or usages that have the force of law.
So it's a really comprehensive
definition.
Meaning fundamental rights have a broad reach. Think of Article 13 as the Constitution, drawing a line in the sand, saying these rights are non-negotiable.
So it's not just about formal acts of Parliament.
No.
Even established practices have to respect these fundamental rights.
Absolutely.
That's a significant check on power.
Yeah, it is.
Let's talk about some specific rights.
Okay.
Article 15 is all about the prohibition of discrimination.
Article 15 is a cornerstone of equality, prohibiting discrimination on grounds only of religion, race, caste, sex, or place of birth. That word only is important because it implies that other factors might be considered. However, it's equally important to note
the exception in Article 15(5), which allows the state to make special provisions for the advancement of socially and educationally backward classes, scheduled castes, and scheduled tribes when it comes to admissions to educational institutions, including private ones. With the exception of minority educational institutions protected under Article 31, This reflects the Constitution's aim to address historical inequalities.
So it's a delicate balance, isn't it?
It is a delicate balance.
Upholding equality, but also trying to level the playing field for historically disadvantaged groups.
I'm thinking it's fair.
Yeah.
Yeah.
Then we have Article 16, which deals with equality of opportunity specifically in public employment.
Article 16.1 guarantees that all citizens will have equal opportunity in matters of employment or appointment to any office under the state. Article 16.2 reinforces this by stating that there can be no discrimination based only on religion, race, caste, sex, descent, place of birth, residence, or any combination of these with respect to any employment or office under the state. Again, there are exceptions. Article 16.3 allows Parliament to make laws that set residence requirements for certain jobs within a state or union territory. And crucially, Article 16.4 permits the state to make reservations in appointments or posts in favor of any backward class of citizens who are not adequately represented in the services under the state. So, while the principle is equality, there's recognition of the need to address historical underrepresentation and regional needs.
So the ideal is equal opportunity, but the Constitution allows for
Affirmative action.
affirmative action
Yeah.
to ensure that ideal becomes a reality for
It's-
all sections of society.
For everyone.
Moving on, Article 22 provides protection against arbitrary arrest and detention, which is a really fundamental
It is.
safeguard
That's so important.
for personal freedom.
Article 22 provides several vital protections, clauses 1 and 2. Grant an arrested person the right to be informed of the reasons for their arrest,
Okay.
and the right to consult with and be defended by a lawyer of their choosing. They also must be brought before the nearest magistrate within 24 hours of their arrest, excluding the time taken for the journey. Clauses 4 onwards deal with preventive detention, which allows the state to detain individuals without trial in certain circumstances to prevent them from committing certain acts.
Okay.
Initially, the Constitution set a 3-month limit for such detention without an advisory board review. Clause 4 stipulates that any detention exceeding this period requires review by an advisory board consisting of individuals who are or have been or are qualified to be judges of a high court.
Okay.
Clause 7 gives Parliament the power to define the circumstances under which a person can be preventively detained for a longer period than 3 months without the opinion of an advisory board, and to prescribe the procedure to be followed by these boards. This part of the Constitution reflects a tension between the need for national security and the protection of individual liberties. And it's an area that has seen a lot of discussion and amendments over the years, although the core principles remain.
So it's a difficult balancing act.
It is.
Trying to protect the state, but also ensuring that individual liberty isn't trampled upon.
It's a tough one.
Yeah.
Yeah.
Next, we have Article 23, which deals with the prohibition of forced labor.
Article 23.1 is very clear. In prohibiting forced labor and the trafficking of human beings, this is a powerful provision aimed at safeguarding vulnerable people from exploitation. However, Article 23.2 provides an exception allowing the state to impose compulsory service for public purposes,
Okay.
as long as in doing so, it does not discriminate based only on religion, race, caste, or class.
So things like mandatory jury duty
Yes.
or conscription, if applied without discriminatory intent,
Exactly.
could be permissible.
Yeah.
So the state can require service for the common good, but it has to be applied fairly.
Right, fair.
Following that, Article 24 directly addresses the issue of child labor.
Article 24 is quite direct and incredibly important, prohibiting the employment of any child below the age of 14 in any factory or mine, or in any other hazardous employment. This reflects the Constitution's deep concern for the well-being and development of children. It's a non-negotiable protection.
Absolutely vital protection.
It is.
Now let's shift to the realm of personal belief.
Okay.
With Article 25, which guarantees freedom of religion.
Article 25.1 guarantees to all persons equally the freedom of conscience and the right to freely profess, practice, and propagate their religion. But this is subject to public order, morality, health,
Okay.
and the other fundamental rights.
So while religious freedom is a fundamental right, it's not absolute.
Absolute.
So, yeah.
And can be reasonably restricted in the interest of
Broader societal well-being.
broader societal well-being.
Yeah.
So you have the right to your beliefs and to share them. but not in a way that
disrupts society.
Disrupts society.
Or infringes on others' rights. Or infringes on others' rights.
Right.
Then we move into the cultural and educational rights, starting with Article 29.
Article 29(1) gives any section of citizens residing in India who have the distinct language, script, or culture the right to conserve that language, script, or culture. This recognizes and protects the incredible diversity of India. Article 29(2) further ensures that no citizen can be denied admission to any educational institution maintained by the state or receiving aid from state funds based only on religion, race, caste, language, or any of these factors.
So if an institution is run by the government or gets government funding, it can't discriminate on these grounds when admitting students.
Exactly.
And this leads us to Article 30, which specifically addresses the rights of minorities.
Article 31 grants all minorities, whether based on religion or language, the right to establish and administer educational institutions of their choice. This is a very significant right. That allows minority communities to preserve and promote their unique cultural and educational identities. Article 31A adds that if the state compulsorily acquires the property of a minority educational institution, the compensation provided must be such that it doesn't restrict or undermine the right guaranteed under Article 31. Furthermore, Article 32 prohibits the state from discriminating against any educational institution managed by a minority, whether based on religion or language. When it comes to granting financial aid, these provisions really highlight the Constitution's commitment to protecting minority rights.
These provisions really underscore the Constitution's commitment to protecting the rights and identities of minority communities within India.
Absolutely.
And finally, in this section on fundamental rights, we come to Article 32, often described as the most important article of Part 3.
Article 32 provides the crucial mechanism for enforcing all the fundamental rights we've been discussing.
So this is where the rubber
hits the road.
It's the road.
It gives individuals the right to directly approach the Supreme Court if they believe their fundamental rights have been violated. The Supreme Court is empowered to issue various writs, like habeas corpus mandamus prohibition, certiorari and quo warranto, to ensure these rights are protected. Importantly, Article 32(4) states that this right to constitutional remedies cannot be suspended except as explicitly provided for in the Constitution itself.
So you can't just take this right away.
No, you can't just take it away. This underscores the fundamental and almost inviolable nature of this right to seek justice if your rights are infringed.
Wow.
Think of Article 32 as the teeth behind the fundamental rights.
So if your fundamental rights are violated, you have a direct line to the highest court in the land.
To the Supreme Court.
To seek a remedy.
That's right.
That's a powerful safeguard.
Yeah.
Now let's shift our focus to Part 4.
Okay.
Directive principles of state policy. These aren't fundamental rights in the sense that you can directly go to court to enforce them, but they're still incredibly important. There's guiding principles.
There's guiding principles
for the government.
For how the government should act.
Yeah.
Article 37 makes it clear that these principles are fundamental in the governance of the country, and it's the state's duty to apply them when making laws.
So they have to think about them.
They have to keep them in mind. While courts can't directly enforce them, they serve as moral and political guidelines for the state in its policymaking and legislative actions.
Okay.
Article 38(1) emphasizes the state's responsibility to strive for a social order that promotes social, economic, and political justice.
So these are big goals.
Big goals.
Yeah.
Article 38(2) further directs the state to work towards minimizing inequalities in income status, facilities, and opportunities. So these are the goals that the government should aim for in the long run, even if they can't be immediately achieved through court orders.
So these are like the ideals.
Yeah, the ideals.
That the Constitution sets out for the state to work towards, even if they aren't immediately
legally enforceable.
Legally enforceable.
Yeah.
Can you give us some concrete examples?
Certainly.
Of these principles in action?
Article 40 directs the state to take steps to organize village panchayats and empower them to function as self-governing units.
Okay.
This principle has been a driving force behind decentralization efforts and the strengthening of local governance.
Over the years.
So bringing power down.
Putting power down.
To the local.
To the people.
Yeah.
Article 41, within the limits of its economic capacity and development, encourages the state to make effective provision for the right to work, to education,
Okay.
and to public assistance in cases of unemployment, old age, sickness, and disability.
Okay, so that's a lot.
That's a lot.
Yeah.
Article 42 calls for the state to make provisions for just and humane conditions of work and for maternity relief.
Article 43 encourages the state to secure a living wage, conditions of work that ensure a decent standard of life, and the promotion of cottage industries. And Article 43A takes this further by urging the state to take steps to ensure the participation of workers in the management of industries.
Wow.
So while you can't sue the government directly, if these aren't fully realized, they provide the framework and direction for the state's policies and laws.
So it's not legally enforceable, but it's like a
guideline. A goal to strive for.
Yeah. It paints a picture of the kind of
welfare state
that the Constitution envisions.
Exactly.
Now let's move on to the actual machinery of government.
Okay.
Starting with Part B, the Union. This part lays out the structure for the executive, legislative, and judicial branches at the national level.
Right, the big three.
Let's start with the head of the executive, the president.
Okay.
Article 54 describes how the president is elected.
So the president isn't directly elected by the people. Instead, Article 54 specifies an electoral college consisting of the elected members of both houses of parliament, Lok Sabha and Rajya Sabha, and the elected members of the legislative assemblies of the states. This indirect election reflects the president's role as the head of state, a largely ceremonial position, while the prime minister holds the real executive power. As head of government, Article 58 outlines the qualifications for being president. Must be a citizen of India, at least 35 years old, and qualified to be a member of the Lok Sabha. Article 59 lays down the conditions of the president's office, including not being a member of parliament or a state legislature, and not holding any other office of profit. Article 60 prescribes the oath the president takes, promising to preserve, protect, and defend the Constitution and the law. And Article 61 details the process of impeachment.
17. Temporary, Transitional, and Special Provisions. Part 21. Article 370. Special Provision for Jammu and Kashmir. This article, in its historical context reflected in this excerpt, granted special status to the state of Jammu and Kashmir, allowing it to have its own constitution and limiting the application of the Indian constitution except for matters in the instrument of accession and other matters with the concurrence of the state government. The provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Article 371, c. The President could specify exceptions and modifications to the Constitution's application to JK, with consultation or concurrence of the state government depending on the matter. Article 371a, Special Provision with respect to the state of Nagaland. This article grants special provisions to Nagaland, including specific applicability of certain laws, special responsibility of the governor for law and order, and provisions for a regional council for the Tunsang district. No act of parliament in respect of I. Religious or social practices of the Nagas, e. Naga customary law and procedure, e. Administration of civil and criminal justice involving decisions according to Naga customary law, if. Ownership and transfer of land and its resources, shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Article 371a, 1a. 17. Temporary, Transitional, and Special Provisions. Part 21. Article 370, Special Provision for Jammu and Kashmir. This article, in its historical context reflected in this excerpt, granted special status to the state of Jammu and Kashmir, allowing it to have its own constitution and limiting the application of the Indian constitution except for matters in the instrument of accession and other matters with the concurrence of the state government. The provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Article 371, c. The President could specify exceptions and modifications to the Constitution's application to JK, with consultation or concurrence of the state government depending on the matter. Article 371a, Special Provision with respect to the state of Nagaland. This article grants special provisions to Nagaland, including specific applicability of certain laws, special responsibility of the governor for law and order, and provisions for a regional council for the Tunsang district. No act of parliament in respect of I. Religious or social practices of the Nagas, e. Naga customary law and procedure, e. Administration of civil and criminal justice involving decisions according to Naga customary law, if ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. Article 371A, 1a.